This is Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Well, hi, Gary. Welcome to the altar of Bard. We're soldiering through La Cañada having no power, at least where I am this morning. How are you?
So far, so good. We've still got power down here as Hurricane or Tropical Storm Hilary ravages Southern California, but I appreciate you making the time even without the power.
Yeah, it's interesting. I was just telling you, I think off air, that La Cañada's got a third world feel to it every time there's any kind of inclement weather. Then I was reading an op-ed this morning by Brian Williams, who I've known for many years, not the ex-NBC anchor, but former city attorney, now works for a foundation, who had written an op-ed about his son, African-American youth, being hassled by some 60-some-odd-year-old pickup truck driving guy in La Cañada for sitting outside of their gated house. And I was going to call him this morning and tease him about when my son was that age and how he would get hassled in La Cañada. So I don't know that it necessarily is race related as much as it's teenager related, but reasonable minds can differ. Having said that, quite a week this week. For those who haven't noticed, or listened last week, Hunter Biden, which we talked about the last week as our lead, the cases were dismissed this week. And so some people were saying, well, what does that mean? I'll tell you what it means. I think I'd mentioned to you, Gary, and say I sometimes read the comments. For those of you who were in the comments saying that this was going to be in Delaware or was going to be in D.C., and I had told you that I thought there was clearly going to be a California filing. It's now apparent that there's going to be a California filing. What they did is they dismissed the cases because they'd reached an impasse in the plea bargains negotiation. For those who aren't in the weeds, what happened is they had a plea agreement under Rule 11. They presented to the judge. The judge asked some questions in the colloquy that were not exactly beating them up, so to speak, but basically, what's the extent of what I can do and can't do, which were extremely reasonable because it was a rather unusual plea agreement in the sense that not only was there a diversion attached to it, but there was and the diversion was for the gun case. Right. But it suggested that it wrapped up everything as a global disposition, which the judge probably had not seen before. And I can tell you, practicing in the federal courts, criminal defense for decades, that is highly unusual to have that suggestion. So for whatever it's worth, what was your reaction to it this week?
Yeah, I mean, it was certainly, the dismissal certainly indicated that it's going to be a larger situation, and the fact that the diversion was attached to it, and that they were trying to say that it was a global, cover, that no more investigation into him was going to happen, was very unusual. And I've seen that I believe his lawyers have tried to force the diversion to go forward, saying that part of the agreement was in fact sound and therefore had to go forward. But it seems like this is going to be a larger thing going forward.
Well, and his lead lawyer, and I forget his name, and I apologize, maybe Gary can find it, I'll give him a shout out, resigned this past week also. And the reason he resigned, and been there, done that myself, is that he believes he's going to become a witness, and probably as to whether or not the parameters of the plea bargain and more specifically the diversion should be specifically enforced. It's an interesting concept, and there's some kind of detrimental reliance based on that, or some other theory by which they want to compel the diversion. More power to them if they can get somebody to do that. It's oftentimes very. One of the reasons is, and you saw the judge talking about this in the colloquy with the prosecutors when she first put back. She she stated that she did not want to overstep her separation of powers kind of wall, if you will, or lane. She didn't want to get out of her judicial lane and become kind of a surrogate for the prosecution.
Yeah, it was interesting to see a judge say that and to say, outright, like, I'm not sure if I'm allowed to do this, and I'm not going to go ahead and rule until I have more time to figure out exactly, what my authority is here. Christopher J. Clark is the lawyer that you were looking for there, sir.
Yeah, and by the way, I don't know him, but by observation, I will tell you, extremely sharp. He's done some amazing work on this, and got to the point where he apparently thought he had an agreement, then pushback from the judge. Then the judge invited them to go and clarify the things that she had questions about. And then I believe what happened was, I was thinking before, they couldn't get her coverage and they didn't want to plead and leave that open. It also appears that maybe the suggestion is that the prosecutor had backtracked from what they had agreed to, and that's why there was a impasse here. And basically, all bets are off. The argument is over. Once the government filed the motion to dismiss, that basically throws down the gauntlet and tells you that this thing is either going to trial or they're going to separate into other districts. And then we'll see what happens. Separating into other districts, especially the California case, I think is a good thing for Biden for a variety of reasons, not the least of which is the jury pool.
Yeah, I think you're probably right there. Sorry. Yes, I think you're probably right there. I think that probably does bode well for him, but it's got to be a shock for the administration, who thought they were rolling into a nice, neat and tidy plea deal, and now all of a sudden here we are, 10 to 14 days later, and everything has just exploded. Right.
There's also been some reporting. I don't know if it's true. I'd love to find out that there was White House pressure, and I don't know if it's true, upon the Georgia prosecution team to get that indictment of Trump done to deflect, which is kind of interesting if that pans out. And you'll remember that I think that there was evidence that the indictment was posted on a website prior to it being voted on or being returned as a true bill by the grand jury as well.
Right. So that was
interesting.
That was posted early in the week, and then there were a few more days before it was actually truly released. And you're talking about the Georgia, find me 11,000 more votes indictment by Fani Willis. There was Trump and 18 co-conspirators that were indicted, 41 counts across all of his 4 cases. It's now 91 counts against former President Trump. And he had threatened a press conference tomorrow that has since been canceled at the urging of his lawyers. He's being prosecuted by Fani Willis under the state RICO organization, which is interesting. RICO Act, not organization, the state RICO Act, which is interesting because this is the only one of the cases where if he were to win, there's nothing he can really do about this one because it's at the state level. He can't direct the Department of Justice to ignore the investigation or to stop pursuing charges. So it's possible that if he were to win, that this could still be going on while he's sitting president.
So one of the things that it's already been filed, Mark Meadows, who was his chief of staff, who's one of the co-defendants in Georgia, has filed a motion. I don't know if you have it, Gary. I probably didn't give you fair warning. He's filed a motion to remove the state prosecution to federal court. There's under the removal statute, somebody who alleges that they are being prosecuted or they are being the jurisdiction of a state entity is being used against somebody in their capacity as a federal doing their federal job. Mark Meadows, as you remember, is a former congressperson who became the chief of staff and was chief of staff for the tail end of the Trump administration. He was indicted by Georgia. There is the motion. Now, the notice of removal is interesting. You will see that they've invoked the code section there, 28 USC 1442 and 1455. The argument is that the conduct giving rise to the charges, basically all of the RICO, all occurred during his service as chief of staff. Federal law then says a prompt removal for criminal prosecution commenced in a state court against or directed to a federal official in his capacity. And then, mind you, that would ensure, for example, that the state court for an alleged offense against the state, and they've cited this 2007 case, which is interesting. I won't go through all the details, but maybe Gary will have a link to it or can tell you where to find it. It's an interesting motion because taking a look at it, it's not a high bar, if you will, for the removal. It would appear to be a motion well taken. So then you have a situation where if Meadows gets removed to federal court, then what does that mean? There's been a lot of the analysts are saying, or the commentators are saying, well, that the state prosecutors would still prosecute the case, but it would be in federal court. I'm not so sure that if it gets removed, that the next motion by Mark Meadows' team is to disqualify the prosecutors. Nobody that I've heard has talked about that. But I think there's a basis once they get it removed to federal court for them to bring a motion to disqualify the prosecutors and to have either a special counsel analyze this and take a look at it, or in the alternative to have Department of Justice weigh in as to whether or not this can be the state prosecutors can prosecute this case. If that's the case, everybody who's been talking about or kind of making the prediction that Trump could not do something about this case if he was elected, I'm not so sure. Once it's in federal court, and if he becomes the president again, I can think of 3 or 4 different maneuvers that he could do to forestall this case. Now, you have if Meadows is successful, I would imagine that Trump would do the same thing, that Trump would move to remove his case to federal court as well. And why do I say that there's some various moves if he were elected? You might remember the Paula Jones case many years ago that went all the way to the U.S. Supreme Court. Unanimously, they allowed Paula Jones's case against Bill Clinton, then President Bill Clinton, to proceed because they said it was a civil matter and that that Clinton would not be sidetracked or deflected from doing his job. What remains open and under the current interpretation of that case is, however, that you could not bring a criminal case against the sitting president during the time that he's president. If you get it removed to federal court, and by the way, this arguably could apply to state courts as well, because remember, there's still one more Alvin Bragg prosecution that's in the Manhattan court. If he's elected, there is an argument under the Jones v. Clinton U.S. Supreme Court case that the criminal proceedings, all the criminal proceedings, whether it's the 2 Jack Smith classified and the so-called January 6th case, this case in Georgia and the case in New York, whether all of those would be timeout and paused. I would imagine that that's what his lawyers are counting on. That is why he's, it's not the only reason he's running, because he would make the argument that the only reason he's being indicted is because he's running. But I would imagine that the lawyers, and he's got a very able lawyer in Georgia, Drew Findling, who I've seen a couple of articles on. I've known of Drew in some of his cases. He's he lives in the hip hop world of criminal defense, is something that I'm in with some regularity. He's a very able and competent lawyer, and I would imagine that he's thinking through a lot of these issues and how to kind of structure what the kinds of things they're going to do.
Well, where would you say that this latest indictment ranks in terms of, danger for Trump? Let's assume that, let's set aside the idea of whether or not he gets a transfer to federal court. Just as it stands now, where would you say this ranks in terms of peril for him?
I look, ultimately, if this gets to trial, this has a great deal of peril to him. However, if I'm ranking the four cases and which are the most likely to get to trial, that's also an interesting global kind of strategy that the lawyers are going to have to analyze. It appears to me that the hush money trial is on the slowest track. It appears to me that case basically will be that they'll stand down on that and defer to the other three. The Georgia case is, I think, the most unlikely to go forward anytime soon. And I say that because somebody's going to have to navigate the various removals to federal court. How many of the defendants actually get removed to federal court? You've got 19 defendants. That is an unwieldy, to be the judge and to be the traffic cop on that. You've got discovery issues. You've got all kinds of lawyering issues. You've got 19 lawyers, 19 defendants, maybe 38 lawyers and 19 defendants. That to me is if I'm going to handicap this, is the least likely to go to trial the soonest. Now, that leaves you, if you take the two state court prosecutions and say, Alvin Bragg is basically telegraphing that he's going to stand down for the others, that the other one in Georgia is the least likely, just as a practical matter, to go to trial. That leaves you with Jack Smith classified documents in Palm Beach and the one in D.C. The D.C. judge is telegraphing she's got that on a fast track. And that, if I were him, if I were advising him, that would be the one I worry about most, because that's a jury pool that is a real problem for Trump. Number one, he's got a judge who's basically got him also on a fast track, as opposed to what appears to be in the classified documents case. He has the ability, if he wants to ram that through, he being Trump or the lawyers, if they want to move that case fast because they think they can get an acquittal in the Palm Beach case, there may be that as a consideration where they say, hey, you want to try a case before the election? If they're thinking, we want to get a win, that may be where they go in terms of trying to get a win. And by the way, it was also the previously filed case, meaning first in time. Generally, in the federal courts, if you've got the same defendant, and this works in state court as well, you always go to the low number case. That is the low number case, meaning it was the first in time. That should arguably take precedence over the DC case. If I'm thinking from the defense standpoint, I do not want to go quick on the DC case. I would rather forestall that by using the case in Palm Beach, the classified documents case, and tee that up first. If you're going to have to try a case before the election, arguably, and what they're making the argument for now is, or setting it up, is that they're going to try and argue that you've got to defer all of these trials until after the election, which is how many months away? 14 months away?
Something like that. Yeah. 14 or 15. Is that, what do you think their likelihood of success is in trying that argument? Because I agree it does appear that's what they're going to try to do.
Well, every time you see the calendar, I've seen both on all ends of the spectrum. They do a calendar, and then they have kind of all the cases and legal cases that he's got, whether it's E. Jean Carroll, whether it's the 4 criminal cases. They put it on a calendar, they superimpose it over the election schedule, and you can see where the Iowa caucuses, Super Tuesday, all of these things are interspersed and interlineated with the trial schedules or the court appearances that are happening. I think that's a very heavy lift to get all 4 of them past the election. But there may be a world in which one case, and if I were betting, I would say the Palm Beach case, where they kind of push forward and focus on that case and try to get the other 3 to stand down for the time being. Their struggle is going to be, as I indicated before, the D.C. case has got a judge who does not appear to be open to that.
Yeah, it's going to be interesting to see whether or not that judge will stand down, because I think that D.C. case is probably not as strong as the Palm Beach case.
Yeah, he's got, I know what they've already started putting together. You can see the parameters and the universe of what they're going to argue. There was a statement that he made on the 7th, I believe, that will be probably Defense Exhibit A to show that he didn't have the intent. Now, the argument from the prosecution is going to be, oh, come on, that's when he realized that it had failed, and that's why he released it. And there's all kinds of texts and people imploring him that were close to him that he's got to make a statement. He was resisting. And so that's where that fight is going to be. That battlefield will be, he will be saying, or the defense will be arguing that that's not what he intended, that he's got free speech. And by the way, this is probably the gravamen when people talk about free speech, core political speech. And that's what his speech is. Core political speech is the most sacrosanct kind of language that is governed by the First Amendment. Now, the argument is going to be by the prosecutors that he had crossed the line. That is a heavy lift for the prosecutors. And so I'd agree with you.
Jewelry is having a big moment right now, and with hundreds of products popping up in your feed every day, it can be hard to find a brand you trust. Alex and Ani has been creating meaningful jewelry for over 20 years, designing pieces that connect you with all of life's important moments. With an emphasis on value, there's truly something for everyone. You might be most familiar with their signature charm bangle. This bracelet literally created the category of meaningful jewelry and had you stacking charms from your wrist to your elbow. This piece is an icon for a reason. Completely size inclusive, each bracelet is adorned with a symbol designed to tell your story and express your unique style. Beyond the bangle, you'll find stylish, affordable jewelry for every occasion, from classic pieces to bold statement looks. Don't know where to start? Alex and Ani makes it easy to unpack the trends you're after and sprinkle in your personality too. Each piece comes with a personalized message and meaning, truly making it the perfect gift. You can take comfort in knowing that you're shopping with a socially conscious brand as well. To date, Alex and Ani has donated over $60 million to nonprofits worldwide, connecting fashion and philanthropy in an easy, fun, affordable way. Visit alexandani.com right now to discover the confidence that comes with a perfectly accessorized piece of jewelry. Right now, Alex and Ani is offering our audience 20% off with code MIDAS at checkout. Again, head to alexandani.com. That's alexandani.com and use code MIDAS at checkout for 20% off your order.
Yeah, absolutely. All right, Mark, anything else you want to cover today?
No, we had I wanted to talk about the judge in your neck of the woods who's now up in our neck of the woods, but maybe we'll drop another one. Gary, you want to summarize this case just so people are aware of it, and then we'll get to it?
Absolutely. So what you're referring to is a judge in Anaheim who was out with his wife for dinner. They were drinking. They were arguing. There was an argument about, who knows what. And he did, the finger gun at her. And she apparently, the argument continued after they got home. Their son, who is in college, was home from college. And she said at one point, "Why don't you point a real gun at me?" He takes a 40 caliber Glock out of his ankle holster, points it at her, and ends up firing, and she ends up dying. He then texts a few members of his staff, his bailiff and court reporter, and says, I just shot my wife. I'm not going to be in tomorrow. Anaheim PD shows up, arrests him, and he is now being charged with murder. He's out on $1 million bail. His son was the one to call 911. He then subsequently called 911 and said that his wife had been shot. The 911 operator said, "Did you shoot her?" He said, "I don't want to talk about that." It's an interesting case. It's something we're watching, and I think we can cover in a future episode. But that's the situation out of Anaheim, and he's now up in Los Angeles County, and he's, I believe, out on bail with a GPS and alcohol monitor and
turned his passport in. And for those of you who are wondering, how do you try a judge in Orange County who's sitting on the bench in Orange County and who was a DA in Orange County before that? You don't. LA accepted the kind of lateral from Orange County as the adjacent county. So the case will, as of right now, will be tried in LA County. Paul Meyer and John Barnett, his two very able lawyers, are already telegraphing that they may move to change venue in this case. And that'll be an interesting legal issue to cover as well in the coming weeks. Gary, thank you for doing this in the prelude to the hurricane, if you will. And
yes,
hopefully I get my power back on soon and we can revisit this. Absolutely.
And Mark, thank you as well. And apologies for any audio issues. Mark is working off a cell phone and AirPods because he has no power, but Hurricane Hilary will not defeat us. We will soldier on. So Mark, thank you so much for your time.
Thank you, Gary. Good to see you.
You as well. Bye-bye.
Thanks for listening to Reasonable Doubt. Subscribe on YouTube at youtube.com/Reasonable Doubt Podcast.